Good morning, everyone. It is also great to just see people. Even Tony's face looks beautiful, being around people for a change. I had to get that in. It was either him or Stan, and Stan would cut my brake line, so I can't make fun of him. It is great to see you all. This is one of the wonkiest subjects, but I think it's one of the most impactful for our state. The McGirt decision is not a problem. There are people who call McGirt a problem. It's not a problem. It is an opportunity for our state to undergo a bit of a transformation, to realign some relationships, but it's going to show how well and where we need to work more for our state and our tribes to work together for the betterment of all people who live within the reservations, who live within our state, tribal and non-tribal. So with us today, we have two people. Two of the smartest, well, virtually with us, we have two of the smartest attorneys I've ever met. Sarah Hill, who is the Attorney General for the Cherokee Nation, and Mithun Mansinghani, who is our State Solicitor General. He works in Attorney General Mike Hunter's office. Sarah has been with the Cherokee Nation for a number of years. She was their first Secretary of Natural Resources. And then when Chief Hoskins was sworn in a couple years ago, she moved over and became their Attorney General. She's local. She went as law grad from the University of Tulsa. And as I said, she's one of the smartest attorneys that I've ever encountered, especially on tribal issues. Mithun, I have to start by saying, went to Harvard. Contractually, Harvard grads have to have that announced 2 or 3 times. So Mithun did go to Harvard, and I need to say that for him, but he is absolutely brilliant as well. He is somebody, just kind of keep an eye on him. He is going to be going somewhere pretty far, I believe, in the days and years ahead. I'm going to stop talking because I'd like to turn it over, I believe, first to General Sarah Hill with the Cherokee Nation to talk a little bit, and then to Mithun. But as you hear them speak, if you would pick up the question cards, write down any question you have. Chamber staff will be picking them up, and we'll cycle through those after the two speakers have gone through some initial remarks. And I will say lovingly to both of the attorneys, brief, so we can get to questions and have a great dialogue. Remember, you can't build these folks for your comments, so keep it short anyway. So, General Hill.
Thank you. I really appreciate being introduced by Derek. He's always got a lot of great ideas, but as often is the case, I'm going to disregard what Derek just said, and then pass it to Mithun, because I think actually he and I discussed it, and he is going to go first. So we're going to appreciate Derek and then just disregard what he said and let Mithun kick it off.
Thank you, General Hill, and thanks, Derek, for the introduction. And I also do not lightly disregard what Derek said, but got to stick with the plan. Well, first of all, it's a pleasure and honor to be invited to speak to y'all. Sorry that we're not quite at the point where I can be there in person, but maybe sometime soon. And in keeping with Derek's admonition, I'm going to obey him and trying to keep this brief. So I want to start with the basics of the McGirt decision, just so kind of everybody understands and is on the same page about what it's about and where we go from here. So the case of Jim C. McGirt actually starts in Broken Arrow, and it starts with some pretty sad realities. Mr. McGirt repeatedly molested his 4-year-old step-granddaughter in Broken Arrow and was sentenced to life in state prison for doing so. After a number of years, it may have been 10, 20 years, he started to raise a claim because other prisoners in other cases started to raise a claim that the state of Oklahoma never had jurisdiction to convict him of his crimes because he was a member of the Seminole tribe, as was his victim, and that much of eastern Oklahoma is part of the Creek Indian Reservation. Now, why this is important, why whether or not eastern Oklahoma is reservation land is important, is that generally under federal law, states don't have jurisdiction to prosecute major crimes committed by tribal members on reservation land. And so the question was not about whether he committed his crime, we're all very confident that he did, but whether or not the land that he committed his crime on was an Indian reservation. And ultimately, the Supreme Court agreed with Mr. McGirt and held that when Congress went through the process of creating the state of Oklahoma, and if you want to remember back to your Oklahoma history classes as a kid, there was the combination of the Indian Territory in the east and the Oklahoma Territory in the west, that as Congress did that process, it never ended the Creek Indian Reservation that was part of the Indian Territory. The technical legal term that you may hear is it never disestablished the Creek Indian Reservation. And of course, the Creek, the Muskogee Creek, were not the only tribes in the Indian Territory. It was primarily composed of the 5 tribes, the Choctaw, the Chickasaw, the Cherokee, the Seminole, as well as the Creek. So the assumption is that if the Creek retained their reservation past Oklahoma statehood, the same would be true with those other 4 tribes. The law and history around that decision is very involved, complicated, and as Derek might say, nuanced. Wonky. And I won't get into that. But I think what's more important for us today is that this puts Oklahoma in a different situation than it was before, but also a somewhat unique situation. So the land that comprises a former Indian territory that is now or will soon to be operating as reservation land is about half the state, both geographically in terms of land area as well as population. And that means that the 1.8 million people who live in the eastern half of the state are now recognized to be living on an Indian reservation. And to put this in perspective, prior to the recognition in McGirt, a total of about 900,000 people across the entire United States lived on an Indian reservation. So we're taking a population that used to be 900,000 and we're adding 1.8 million to it. So in a sense, that the McGirt decision tripled the reservation population in the United States. And then the other, I think, unique thing that puts Oklahoma in a different situation is that many of the people who live on these reservations in Oklahoma are not tribal members. In legal terms, they're non-Indian. The law can sometimes be a little bit slow to move, and we still call it Indian law and refer to tribal members as Indians for the purposes of legal purposes. So if that term sounds a little strange to you, just know that that's what it is for legal purposes. So you want to contrast that with the next largest reservation outside of Oklahoma. That's the Navajo reservation. That reservation is about 90% tribal members, and the Creek Reservation, which is about 7-8 times larger, is about 90% non-tribal members. So it really puts Oklahoma in an interesting place for a couple of reasons. Part of it is because of the very different demographics of Oklahoma's Indian reservations, both in terms of the tribal to non-tribal population and in terms of the size. But it's also puts us in a somewhat different situation because for one reason or another, it hasn't been commonly recognized as a reservation for the last 100 years. And so we have some adjusting to do to adjust that to that new recognition. Whereas most of these other Indian reservations across the country have always been recognized as Indian reservations. So where does that leave us? The most obvious questions are around criminal justice. McGirt and its companion case, the Murphy case, were criminal cases, and the most pressing issues revolve around criminal justice. Because the state doesn't have jurisdiction over these major crimes committed by tribal members, that leaves a lot of other people like Mr. McGirt who are in state prison with the opportunity to be released from state custody. And that doesn't mean that they will go scot-free necessarily, because either the tribe or the federal government, depending on the situation, may have jurisdiction over them. And then, of course, you have new crimes committed every day in eastern Oklahoma that will now have to be shifted towards tribal and federal responsibilities. And that will require many more resources than the federal governments and the tribal governments have put towards criminal justice in the past. And that's an adjustment. And we have been working both at the Attorney General's office and state prosecutors, state police forces, local prosecutors, and DAs have been working hand in hand with tribal officials and federal officials to make sure that those new responsibilities and that transition happens as smoothly as possible and minimize the chances that crimes slip through the cracks and go unpunished. Along those lines, the Attorney General has recommended to Congress that it pass legislation allowing tribes to compact with the state to work together on criminal justice issues, which we can't currently do because of existing federal law. And we're very appreciative that the Cherokee Nation and the Chickasaw Nation have joined us in that call and have taken substantial efforts to move that idea forward. But there have been other opportunities for cooperation in the wake of McGirt. And so one of them that was really important to me, and I know is really important to General Hill, is on Indian child welfare issues. The rules of adopting and foster placement for Indian children are different on reservations than they are outside of reservations. So immediately after the decision, there became issues of not just on what to do with crimes and crime victims, but also what to do with children who may be in neglectful or abusive homes. And immediately after the wake of the decision, the tribes worked with the Department of Human Services and our office and the Attorney General's office and signed agreements to make sure that the state and the tribes can cooperate in making sure all of these children are taken care of. And we're talking about, hundreds, if not over 1,000, thousands of children that are in this system, that are Native American, and that have, I hope, been really, really benefited by the fact that there will not be any interruption in service to these children because of the McGirt decision, and there was not any interruption because the tribes and the state have worked hand in hand in getting that done. And we're looking forward to continued partnerships with the tribes. The most important issues, on our end, that needed to be immediately addressed had to do with child welfare and criminal justice. But I know there are a lot of other issues that have arisen, questions in people's minds about what the McGirt's decision has to do with commerce and business, taxation and regulation in Oklahoma. And I know that's what y'all might be particularly interested in hearing about. And I say that criminal justice and child welfare are the most important issues, in part because of the vulnerable populations that are at issue there, but also in part because the law around those are a much more major shift than they will be for businesses. And so while business and commerce are very, very important, I think that the business community has to be less concerned that the major shift that happened on the criminal justice front is also going to happen on the business and commerce front. The major implications of the McGirt decision are about the questions of state jurisdiction over tribal members. There is going to be less change with respect to tribal jurisdiction or federal jurisdiction over non-tribal members. There is longstanding case law that limits the authority of tribes to regulate non-tribal members on even on reservation land. And we trust also that our tribes have the same interest in the state does, in that there is little interest in imposing regulations or taxes that have negative commercial effects in the state, from the state perspective, and that have negative commercial effects on the reservation from the tribal perspective. So while these questions may come up and while these issues may be raised, I think it's important to approach them soberly and be cognizant of the fact that there is, as far as we've seen, very little will or desire to interrupt the growing economy that Oklahoma has in eastern Oklahoma from the tribe's part or from the state's part. And with that, I think I've kept it brief, and I'll turn it over to General Hill.
So real quick before General Hill starts speaking, Mithin, that wasn't too brief, but also folks here, don't forget to be writing down questions. I've already got one or two, but don't forget to write down the questions and waive it for chamber staff to pick up.
Thank you. As always, Mithin, I think, makes Harvard proud and gives a fair and accurate, rendition of the case and the law and the facts. And I'm going to, change focus just a little bit to talk more about, I think, the perspective, a tribal perspective of the situation. And I agree with, Mithin's assessment of the case and the impacts of it, but just to give a different point of view about it. I think, there are two basic things that dominate the conversation. There's the side of it that are the reasons for concern. And I think there are many reasons for concern, issues that the tribes and the state will need to address. And then the other side of that is, are there reasons for optimism? What is it about the situation that is, and it was really great to hear Derek talk about this in terms of opportunities, because I think, certainly business leaders appreciate that change brings both challenge and opportunity, and it's how you react to that situation that determines whether you've got a better situation than you started with or a worse one. And so much of this is on business leaders, on government leaders today to make good decisions so that we have, we're taking advantage of the opportunities that the situation creates. I wanted to talk a little bit about the scope of the challenge at Cherokee Nation to give all of you maybe an opportunity to appreciate. And I agree certainly with Mithin's assessment that it is the child welfare and the public safety issues that have really dominated the conversation, not because there aren't other important issues, but because those are the issues where Indian country is the most decisive. It's where the law is the most clear that there are certain changes that have to be made if you live on an Indian reservation. And in that space, in the criminal law and in child welfare law, those lines are really clear. There are some bright lines, so we know what the challenges are very specifically there. Cherokee Nation, the reservation of the Cherokee Nation is about 7,000 square miles, which is about 10% of Oklahoma's total land base is in the Cherokee Nation. It does not include the tremendous community of Broken Arrow, but some of the sister communities, the northern part of Tulsa, Owasso. So it certainly is very adjacent to the community that all of you live in. There are about 500,000 people. There are just over 500,000 people on the Cherokee Nation reservation. About 13% of the total population of Oklahoma lives in the Cherokee Nation's reservation. There are about 143,000 Cherokee citizens who live on the reservation, and the Cherokee Nation is the largest tribe in the United States. There are over 400,000 Cherokee Nation citizens, and 143 of those roughly live inside the boundaries of the Cherokee Nation reservation. Based on population, that roughly 25% of the population of the Cherokee reservation is Cherokee. That's a higher number than there are perhaps in other places. I suspect that the number of Cherokees may even outnumber the other tribes on their own reservations because there are so many Cherokees in eastern Oklahoma. In 2019, Cherokee Nation filed 62 criminal cases, which is just probably seems like a ludicrously low number of criminal cases to file. And this is all prior to the decision in McGirt. But that's because the the understanding or the way everyone operated at that time was that Cherokee Nation had criminal jurisdiction over lands that it held in trust or lands that were restricted Indian lands. So there were pockets, patchwork pieces of Oklahoma that the tribe exerted criminal jurisdiction over, including the tribe's business, the casinos. So for most of those misdemeanors that were committed by tribal citizens in the casinos or on tribal trust land, the nation would bring those criminal cases. So it was a very small number. Already in 2021, the Cherokee Nation's filed over 200 criminal cases, and there hasn't even been a decision yet from the Court of Criminal Appeals that a lot of criminal cases in Oklahoma need to be dismissed. That's something that we're expecting will happen. So that's just the tip of the iceberg. So that's going from a 62 criminal cases to a year to many hundreds of criminal cases in a year is a very big change. In 2019, the Cherokee Nation had 1 full-time tribal prosecutor and had about 25 full-time marshals. And that was the scope that we started with when we began building up when McGirt happened, and we realized that the scope of our criminal jurisdiction was getting ready to change very drastically. So that's a challenge that the nation's taken very seriously. And in the past 6 months, the Cherokee Nation has really worked hard to get ourselves in a situation to take on and to meet this new challenge, adding $10 million as an initial investment to improve and increase the number of tribal prosecutors. So I've now got a team of 5 prosecutors who do nothing but prosecute crime on the Cherokee Nation. We've met with every single district attorney, elected district attorney in the Cherokee Nation, began getting case lists from them, all of the cases that they know are Indians, where they know those issues are going to be involved. Begin working on getting those cases filed if the circumstances are where they should be refiled in tribal court. We've worked a lot with A.G. Hunter and his office to talk about how to improve the coordination between our offices. And really, it's a fundamental rebalancing of governmental authority in Oklahoma. That's something that McGirt stands for, is this idea that the tribal reservations are a permanent part of Oklahoma's landscape. And it's something, and that really does change the nature of tribal authority and everyone's understanding of tribal authority in Oklahoma. I say all of that to say, I think there are a lot of reasons for optimism based upon that. And I have a quote that from a gentleman named Fieldon Hill. He is my great grandfather. He was alive during his statehood. He was a non-Indian who settled illegally in Indian territory. And in an interview he did near the end of his life after statehood, he said, "I voted for statehood, all right, but if I had my way about it now, I would like to have it back as a territory as it once was. I made money a lot easier then than I can now, and I tell you, I would be willing to leave here and go anywhere if I could find any place today where things are as they were in those days." And in that interview, he talks about Cherokee Nation's schools and how important they were to the community. He talks about Cherokee Nation's justice system. And so I say that to say, I think there are reasons for optimism that tribal governments can do a good job. Tribal governments have done a good job. And I think we have a track record in Oklahoma that demonstrates a commitment to public safety, that demonstrates a commitment to economic growth. All of the things that people, Indian and non-Indian alike, in Oklahoma need are things that our governments are committed to, which is not to say, obviously, that Oklahoma's not committed to it, but that fundamental rebalancing may bring back into Oklahoma something that maybe it missed and didn't realize, maybe something that it needs and something that could be good for it. And I think having some optimism about the capacity of tribal governments and their ability to influence positively the communities that we live in is something that we need to take seriously. The other thing I think that's a reason for optimism is the long history of tribal-state cooperation. There are a lot of things that we can point to. There are, I think, literally hundreds, maybe over 1,000 compacts now between the state and the tribes in Oklahoma on topics regarding card tags, hunting and fishing. There's just runs the gamut of issues. And those compacts generally arose because there was some dispute about what the nature of tribal or state authority was over some topic. And sometimes there was litigation between the tribe and the state in that process. But at the end of the day, the tribes and the state leaders sat down and figured out something that would work for both entities and implemented that. And we have gaming in our state because of that, and all of the economic benefit that our communities have got from gaming because of that. So I think we have that long history of tribal state cooperation to look at. I think we have the common interests that we have. As Mithin alluded, the tribes are interested in economic development. Not only are they engines of economic development themselves, tribally owned businesses, but tribes, our tribe has worked hard to attract non-Indian businesses to the reservation, and has worked collaboratively and cooperatively with other state entities to make that a reality. So it doesn't benefit, because we have a common interest. I think we have reason to have optimism that we can solve the problems that arise in this process. And I don't mean to say that there won't be. I'm well aware that there will be challenges we'll have to face, but I think there are reasons for optimism. There's evidence that we use the tools that we have to the benefit of both communities when we have those tools. And the ICW agreement that Nathan referenced is an example of that. When we have tools to make agreements, we strike them for the benefit of both communities and can work together quickly when we need to, because I think that that particular agreement was something we were able to get hammered out relatively quickly, because we all understood, children have to be the first priority, and this is what you guys can do, and this is what we can do best, and let's work together. And I think, one of the things that we have in terms of opportunities is we have an opportunity to create, to reduce redundancies and to create to play to our strengths. So one of the things that you could do in McGirt is we could be really redundant. We could build a tribal system on top of an existing state system and have redundant functions. Or if we had the opportunity to compact on criminal jurisdiction, there may be places where the tribes could say, we're really going to focus on treatment. We're really going to focus on drug courts. We're really going to focus on these areas where maybe Oklahoma hasn't been able to invest as heavily as some of these areas that everyone knows our communities need. And instead of building redundancies, we could build a stronger and more resilient criminal justice system that focuses more on root causes and less on detention, which I think is something Oklahomans have really wrestled with over the last few years. And this may be an opportunity for us to really do that. And then on the civil issue, I think it's clear that, if to the extent that issues arise, and I appreciate, the observation that tribes don't seem to have an interest in destroying economic development. I mean, obviously, our elected leaders like to see strong economic growth, like to see communities and citizens in our communities getting, more prosperous, not less prosperous. That's good for any elected leader. And I think that to the extent that civil issues arise that we feel like have to be addressed, I believe that Oklahoma and tribal leaders have the capacity to sit down and work those issues out. And I don't believe that blindly, but I believe that based on the history that we've demonstrated by working together. So that's just a sort of a short snapshot, as much as a lawyer is capable of, Derek, of the challenges that we're facing and the opportunities that we think that are there to be seized.
And you did a great job at that too. So I have a good stack of questions, but if folks have others or you think of some as we get into this, feel free to write it down, wave it around. Somebody will come pick it up. There was some reference to congressional action, and I kind of alluded to knowing these two pretty well. We've been engaged in some conversations over a number of years of, okay, this is coming. So what does this mean? How do we proceed? How do we move forward? I think it's safe to say the goal of the congressional delegation, but also the tribes and the state, is how do we ensure that there's some predictability and certainty? So if you're working on the reservation, whether you're Indian or non-Indian, what does this mean? You know who has authority over you. You know who's regulating your behavior. You know that if you commit a crime, who's going to be the one who arrests you and make sure that you're prosecuted. And I think it's safe to say, they can disagree, but I think it is safe to say everybody engaged in this conversation wants to make sure we get there. And so I've been very grateful to be able to work with these two and a handful of other lawyers over the last few years to make sure that conversation is moving forward and make sure everybody's talking. That's the most important thing. They also said the state and tribes do have a strong and lengthy relationship on working out agreements. And I think that the conversations going on with McGirt signify that we can have those hard conversations and make sure we do what's best for all people living here. So as I said, I have a long list of questions. And I think, because we may have skipped over this at the start, Mithun or General Hill, just very briefly, what does it mean whenever the court said the reservation was not disestablished? What does that mean? General Hill, do you want to take that one?
Sure. So, the treaties between the tribes and the United States set out a land base for the tribes. And it was true in the Creek Nation. It's true in all of the 5 tribes. These treaties, laid out the boundaries. This is the land that's going to belong to this tribe forever. And that was the language of the treaty that that this would belong to these nations forever. And that the court determined established a reservation, reserved this territory for the tribes to serve as a homeland. Now, Congress, I mean, the United States has broken most of its treaty promises, and it certainly, in other places has gone in and explicitly said, we made this promise, but now we are saying that this reservation is disestablished. We are breaking that promise, and we are removing, this is no longer Indian country. But to do that, Congress has to do it really explicitly. They have to say the words, this has been disestablished. And the court found in the McGirt case that in the case of the Creek Nation, Congress had never disestablished it, had never used those explicit words that it would need to use it changed a lot of things about Indian country, but it never disestablished that and never made the reservation and the tribe's authority over that reservation completely go away.
Perfect. And I can say officially on behalf of the congressional delegation, there is zero chance that we ever try to disestablish any of the 5 reservations here or anywhere in the country. That just won't and can't happen for a number of reasons. So the next question on the list is, what does this mean for property owners, tribal, non-tribal, living on the reservation? I live in a neighborhood, I have a house. What does this mean for me? Am I still paying taxes? Who tells me I need to mow my lawn and make sure everything is up to code and all of that? Mithan, do you want to start with that, and then General Hill throw in?
Sure. So you still own your house. We can start with that one. To piggyback a little bit off of what Sarah just said, because people may be thinking, well, if this land was given to the tribes and the court just held that land still is the tribes, do I still own, my land that is on the reservation? But this is not about who owns the land. It's more about how the land is governed. So the state of Oklahoma has jurisdiction over land within its borders, but that doesn't mean the state owns your land if you have a house in Oklahoma, right? You own your land. On a reservation, so if you live in, say, Oklahoma City, where I'm speaking from, well, I'm not speaking from Oklahoma City, I'm speaking from Logan County, but if you live in Western Oklahoma, you generally are subject to 2 governments, the federal government and the state government, and any governments that are subdivisions of the state, like county or local governments. On a reservation, you're subject to potentially 3 governments, depending if you are a tribal member or not a tribal member. Federal government, the state government, and potentially the tribal government. So that doesn't change whether or not you own your land. Part of the process that Congress did do in creating the state of Oklahoma was allowing private ownership of land on the reservation. So that doesn't change. You also asked about taxes. I think it's fairly well established that the state can continue to collect your ad valorem taxes, your property taxes on the reservation as it had before. Now, there were some situations before where it couldn't. Those don't change. But even before the McGirt decision, or as it was before the McGirt decision, the state can continue to collect property taxes, and so along the lines of property taxes and property ownership, I don't really foresee really any changes from what it was before the decision. But I'll pass it over to Sarah to see if there's anything I missed.
Actually,
Hi.
General Hill, if you don't mind, I'll throw in just kind of a hypothetical for you on the business side. Let's say I am a Cherokee citizen living on the Cherokee Reservation, and I own a business, call it a plumbing company operating on the Cherokee Reservation. Who regulates my business? Who taxes the income that I'm making on that business?
So that's a 2-parter. And I think that this is where, on the tax side of it, I think that the individual's tax situation, I mean, Oklahoma Tax Commission, as I understand it, it's basically saying at this point, they have jurisdiction to collect tax from that individual. I think that is a place where the individual could challenge Oklahoma's taxing authority. If you are a Cherokee citizen living on the reservation, your income is derived from activity on that reservation, There are Supreme Court cases which deal with those facts and typically say that the state lacks jurisdiction to tax income under those circumstances. Now, whether that ends up holding true in Oklahoma, in the reservations of the 5 tribes, is something that I think will be litigated. So I would tell that person that if it was their intent to challenge Oklahoma's taxing authority, that they would need to expect that there would have to be litigation about that. Because as I understand it, that's not Oklahoma's position, that would be exempt from tax, state taxing authority. So there's the tax issue. On the regulatory issue, civil, you have 2 different kinds of things that people have to deal with in your life. You have criminal things where you can't go to someone's house and beat them up. That's a violation of the criminal law. And if you do, then you'll be subject to the laws. If you're an Indian and you commit that crime, you go assault someone on the Cherokee reservation, then the Cherokee Nation will be the entity. That's whose law you violated as an Indian on the reservation, and that's who will hold you accountable for that crime. On the civil side, it's not as clear cut. On civil issues and who has civil regulatory authority, it could be that the tribe has civil regulatory authority over you under those circumstances. And in some circumstances, it may be that the state could exert civil jurisdiction even over an Indian. And there are legal tests that are applied in those circumstances. And I think unless Mithan has a better way of explaining it, that's as clear as I can probably get on that topic without looking at an actual factual situation.
Yeah, and as Sarah mentioned, there are going to be challenges and things to be worked out in the future, and I think the issues relating to zoning and business regulation can vary based on whether or not you're a tribal member or not a tribal member, and it can vary based on various demographic and historical issues. Unfortunately, the Supreme Court has been less than clear on some of those issues, and those will have to be worked out, but I don't anticipate them to be, major challenges.
So to boil it down, we can tell Mullen Plumbing when they say who can tax us and regulate it, it depends, which is the standard law school answer that they taught me in the first semester. I want to get over to criminal issues. We've got quite a few questions on that, but very quickly, Mithan, probably this one is for you. The question is, will fines and fees that have been levied against Indians living on the reservation be refunded by the state? Is there a process in place for that yet? How's that going to work?
So that's a good question. That's actually the subject of a couple of cases and class actions, one in, I think, state court and one in federal court. So far, the state has been successful in fighting off those class actions, because the situation that Derek is describing is that once you're convicted of a crime, you oftentimes have to pay a fine. You have to pay court fees for the court's process in taking you through the criminal justice system. And you sometimes also have to pay restitution to the victim. And the last thing we would want is for a victim of some crime to have to pay back money to their victimizer because of these jurisdictional issues. So I guess the short answer is, and it's especially true if you've already kind of served out your sentence. So if you're currently sitting in state prison and like Mr. McGirt was, or Mr. Murphy, and I should preface this by saying, one example of the state's federal and tribal cooperation after the McGirt decision is about Mr. McGirt and Mr. Murphy, both of whom have been retried by the federal government and are now sitting in federal prison because they've been convicted by the federal government. They weren't released out onto the street ever. As soon as that decision came down, we transferred them to federal authorities. When it comes to court fines and fees, if you happen to be the type of person that's eligible to get your conviction overturned, as in you're still serving your sentence or whatnot, then maybe there will be a process set up for court fines and fees. But as for now, those challenges to the state's court fines and fees and restitution have not been successful, and both state and federal courts have decided that the people who are challenging those are not quite going through the right processes to do so.
I will just interject that there's a good chance the person would need that money because they would have to turn around and pay the same fines and fees to the tribal government or to the federal government. So it's maybe more of a transfer of funds around than a return of funds for people who are, they may successfully avoid state prosecution and then immediately be brought over and have a fine assessed against them by the tribe.
So we can just have Governor Stitt write Chief Hoskins a check, just pass it through that way. I wanted to see General Hill's reaction to that one. Okay, so we're going to transition over to some criminal issues. I will give you some homework. If you want to wonk out and really deep dive into what the civil jurisdictional questions are, your eyes will glaze over, but you can look up the Montana case and the Williams case. And you're going to read those and you're going to think, well, this explains everything. This answers every question. Spoiler alert, it really doesn't. But that gives you a starting point if you really want to dive into this. Montana and Williams, those are two foundational cases. But on the criminal side, I want to start with just the very basic question. What is cross-deputization? How does that work? And how is it working right now on the Cherokee Reservation?
So cross-deputization agreements are agreements that have been, these are not new things, these are not as a result of McGirt or Murphy, but these are long-standing agreements between different law enforcement agencies in the reservations. And basically the issue is if you're an officer and you get brought out to a call, you don't know what you might be walking into. You don't know who the victim is. You don't know who the offender is. And therefore you don't know whose authority you're going to be acting under. So if you are on Indian country and you don't know those things, you don't know whether if it's two non-Indians on Indian country, then only the state can exert jurisdiction over that individual who's committed the crime. And so a state officer needs to be the person to respond. If it's two Indians, an Indian who's committed a crime against another Indian, then the tribal authority would be the person who would have jurisdiction. So you need a tribal officer to respond. If it's a non-Indian who's committing a crime against an Indian, then you're going to need federal authority to make that arrest. And obviously, you don't know that until you get there. So the solution to this problem, which has been an issue throughout Indian country, is there some way that we could agree that officers could share the authority of different sovereigns? So I could have one officer who could, if he needed to be a state officer, could wear a state officer badge and then flip that around metaphorically and instead be a tribal officer if he needed to be a tribal officer on that call, or be a federal officer if they needed to be able to do that. So these are basically authority sharing agreements for law enforcement so that they can wear the hat that they need to be wearing without knowing at the front end who has criminal jurisdiction in that circumstance, so that the arrest is proper and they have the proper authority that they need. The Cherokee Nation has cross-stepped with every single municipality, with every single law enforcement agency, state agency in the reservation that has any kind of law enforcement authority, from the smallest cop in the smallest town to the highway patrol. So, and everybody in between. So this is a way to make sure that law enforcement has the tools that it needs and that they don't have to pull out their case books on the ground and decide who has jurisdiction in this case. They can just make the arrest and then let the lawyers sort it out later who needs to prosecute that case.
And I can say, just as an outsider, I'm not in law enforcement, but in dealing with a lot of the cities, particularly smaller cities throughout not only the Cherokee Nation, but most of the tribes in Oklahoma, that process works really well. A lot of smaller towns where there's only a few officers, or it's a volunteer department, tribal law enforcement, I know the Cherokee Nation, I think a couple others, have a SWAT team. There are many smaller towns in Oklahoma that don't have a SWAT team. So they're able to partner and work together. So a small city can say, hey, we need a SWAT team to respond to an incident. They can call the Cherokee Nation, and the Cherokee Nation comes in, partners with them, and helps work through whatever the problem is. It has traditionally worked very well, again, as an outsider looking in. Now, the two of you are going to think I wrote this question. I promise I didn't, but it is a question that deals with the Curtis Act. And the question is, how does the Curtis Act, and one of you will have to explain what Section 15 of the Curtis Act is, how does the Curtis Act affect the authority of a municipality to exercise some kind of authority, criminal or civil, but mainly criminal, over an Indian on the reservation? General Hill, do you want to start with that? And I will note we've only got about 3 or 5 minutes, so brevity, please.
Well, brevity is easier on this one because the Curtis Act really has nothing to do with criminal jurisdiction of municipalities. I know that there are people who have looked at the Curtis Act and have decided that the Curtis Act somehow gives a municipality, which is a subdivision of the state, some sort of super authority there, that even though the state couldn't prosecute that crime, the municipality can prosecute crimes in Indian country against Indians, as if the reservation rules don't really apply to that municipality. I don't think that's correct. I know that their argument is being made, but I don't think anything in the Curtis Act gives municipalities the authority to prosecute Indians for crimes that the nation would ordinarily have jurisdiction over.
Yeah, the Curtis Act issue is something that is sort of in active litigation. So I'm not going to talk too much about it. It's obviously not an argument from the state's perspective, since this is about municipalities, but it actually has come up in the court fines and fees context in those cases that Derek brought up before. You know, and just to give a 60-second summary when we talk about the Curtis Act, this was a law passed in 1898 in the lead up to statehood. And it did a lot of things. It forced the tribes into the allotment process, and I think Sarah can correct me if I'm wrong. It at the time it abolished tribal courts, a decision Congress later reversed in the 1930s. And one of the things it did was that it allowed the organizations of towns in the Indian Territory and said that those towns have to allow both tribal members and non-tribal members alike to vote in town elections and creating municipal laws. And when those tribal members and non-tribal members voted to create municipal laws under the laws of Arkansas, because remember, Oklahoma wasn't a state yet, that those municipal laws would apply equally to both tribal members and non-tribal members. And so the question is, you know, after statehood in 1907, do those rules continue to apply to municipalities? And again, that's something that's starting to bubble up in litigation, but that's just a little background on the Curtis Act.
I haven't seen any Oklahoma towns exerting jurisdiction under Arkansas law at all recently. So it'll be it's an interesting legal argument that people are bringing forward. I have less. I'm not optimistic that the theory that's been put forward is something that the courts are going to support. But you know, I understand the arguments being made.
Well, I've been given permission to keep going for about 2 more hours. We have more questions, so I hope you two are available. Actually, no, I do want to say thank you again to both of these brilliant attorneys. As I said, I've had the pleasure on behalf of Senator Langford of working with both of these two, their respective, well, Cherokee Nation, General Hunter, and 4 other tribes that are likely affected by the McGirt decision, as we had these conversations on what does the world look like post-McGirt. As I said, this case is a Muskogee Creek case originally, but there is widespread belief that what applies to the Creek Nation applies to the Seminole, Choctaw, Cherokee, and Chickasaw. Thank you. Can't forget about the unconquered and unconquerable Chickasaw Nation. So we know that Eastern Oklahoma and much of Southeastern Oklahoma is affected by this. And there are a lot of people that are coming together to say, how do we have the conversations to make sure, again, that there's predictability and certainty for everybody. The sky's not falling. It's just a little different. I'm Southern Baptist. I don't deal with change well, but this change will be okay. We're going to be fine. There's a bright day ahead, I believe, for economic development. Criminal issues are something we're going to have to work on. I hope Congress can get to it this year, sooner rather than later, but we're going to get there and we're going to be fine. So on behalf of the Broken Arrow Chamber, I want to thank both of you for participating, but since I also threw you under the bus and volunteered both of you to do this, thank you. And with that, I do have permission to, I wasn't going to be nice enough to clap for either one of you, but with that, I believe we are adjourned. So thank you all. Have a great day.